I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
All right, folks, today we're dealing with one of the dumbest sovereign citizens I've ever seen, and trust me, that bar is already underground. How these people still exist in 2025 is beyond me. This guy can't even read, yet he somehow thinks he can waltz into court and play lawyer like he's some kind of legal genius. His main argument, he claims the trial isn't fair because he only had 1 hour to study law, while the prosecutor had 7 years of law school. I mean, really? That's like entering the Olympics with 0 training and crying foul because the pros had more practice. This one's painful to watch, but it's also hilariously entertaining. Let me know your thoughts in the comments as you watch this clown get absolutely wrecked by reality. Let's dive in.
People of the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of freedom of speech and the rules of professional conduct, I'd like to read my motions.
My goodness, this man can barely read, and now he wants to stand up in court and read his own motions like he's some kind of legal mastermind. Be honest, what would you rank his reading level? I'd say maybe 6th grade, and that's being generous. But here's the real kicker. He's actually complaining that he hasn't had enough time to study the law. Like, sir, do you really think the judge is going to hit pause on your case for the next 7 years so you can go earn a law degree? The entitlement is unreal. Back in my day, if you didn't know how to do something, you found someone who did. You didn't throw a tantrum and expect the world to rearrange itself for your convenience. The court has already given him option: a lawyer, take a public defender, or represent yourself if you know what you're doing. Clearly, this man does not. What's next? Is he going to ask for a delay so he can be sworn into the Supreme Court? Let me know what you guys think about this mess so far. Now, let's dive back in and watch this train wreck unfold.
All right, go right ahead.
For every waste of time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on, and I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
is anybody else just waiting for the judge to hit him with a nice speech? Little guy, motion denied, because honestly, that's exactly where this is headed. This dude really acted like he was delivering the Gettysburg Address instead of reading a motion that had zero legal weight. I honestly think the judge only let him read it out loud for entertainment value. Like, sure, go ahead, let's all have a laugh. Because if we're being real, she could have shut him down immediately. Judges have the authority to deny ridiculous motions on the spot, especially when they're just wasting the court's time. And this right here is a textbook example. Rule 11 of the Federal Rules of Civil Procedure literally exists to stop people from pulling stunts like this. You file a motion with no basis in fact or law, you can be sanctioned. But hey, maybe he thinks if he talks long enough, the judge will be hypnotized by his sovereign citizen wisdom and dismiss the whole case. Spoiler alert, that's not happening.
Impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature, to the extent that he's setting himself up or trying to set himself up for these objections. I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, in the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this guy playing dumb? Or is he just genuinely this clueless? I'm leaning toward playing dumb because there's just no way someone facing actual jail time can be this brainless. This isn't a high school pop quiz. You can't just wing it and hope for the best. His entire defense falls apart with one simple fact. He could have had a court-appointed attorney for free. But instead of using that help, he'd rather waste everyone's time filing garbage motions and then complain that he only had 1 hour to study for court. Like, what did he think this was? An open book test? He reminds me of that one kid in school who clearly didn't prep his presentation. So he just starts rambling nonsense and praying no one notices. Newsflash, we all notice. Let me know in the comments. Do you think he's faking it, or is this the real deal? Let's dive back in.
And it states that as a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22 when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
Perfectly said. Honestly, I think the judge handled this one really well. Sure, she could have shut this clown down sooner, but then again, we wouldn't have gotten such a solid laugh at his expense. But seriously, what was this dude thinking? When he walked into court today, did he really believe he was about to finesse his way to victory? With a crumpled up motion he probably found on the jail floor. This is exactly why knowing your rights matters, not so you can spew made up legal nonsense, but so you don't end up like this guy, embarrassing yourself in front of a judge who has zero patience for games. At the end of the day, courts don't play around with garbage like this. Sure, the judge was patient. She even gave him a few words at the end, but come on. The dude literally had free legal representation standing by, and he still chose to go full sovereign citizen mode. It makes no sense. This was easily one of the dumbest legal arguments I've ever heard, like ever. He's a walking case study in what not to do in court. Newsflash, the law isn't a choose-your-own-adventure book where you get to make up the rules as you go. But hey, at least we got some quality entertainment today. I'd probably rank this guy's reading level somewhere around 6th grade. Actually, scratch that 3rd grade after hearing that last bit. Let me know if you agree. If you enjoyed this one, hit that like button, subscribe if you haven't already, and drop a comment if you have any wild court hearings you want me to cover. I post every single day, so I've got you. Thanks so much for watching, and take care, everyone.